Thank you very much, Wes. So yes, my name is Ayelet Berman. I'm the co-chair of the American Society of International Law, International Organizations Interest Group. And on behalf of our interest group, the International Organizations Interest Group and the International Law and Technology Interest Group, which is headed by Asaf Lubin, who is here with us today. It's really our utmost pleasure to welcome all of you to our panel today entitled The International Law of Data Protection and the Responsibility of International Courts and Organizations. This is really the first collaboration, at least during our tenureship, between the IOIG and the technology group. And I really want to start off by saying thank you to Asaf for taking the lead on organizing this panel. And I really hope that this will be the first of other fruitful collaborations between the groups. So the topic of today's panel is essentially the use of data and international organizations. And I think that Yuval Noah Harari said it really perfectly in his most recent book entitled 21 Principles for the 21st Century, where he says, quote unquote, those who own the data own the future. So essentially, really, data is a token of power in this day and age. And of course, as international lawyers and lawyers more generally, really our main role and one of our main roles and responsibilities is to prevent the abuse of power. And as such, really, the matter of data regulation is really, and I think many will agree with me, it's really one of the most central legal questions of our times. Quite obviously, there are many developments in the field, there are many debates, discussions, but I really think, at least as far as I've seen, there really hasn't been a lot of debate on this issue in the context of international organizations. So how really is the use of data regulated in the specific context of international organizations, international courts? And so I'm really excited about the panel today because this is really, I think, one of these first opportunities to hear from experts in the field and get a better understanding of how this is happening in international organizations. And with that, actually, I really want to just present our excellent panelists today. So as I mentioned, Asaf Lubin, he's the co-chair of the International Law and Technology Interest Group, and he's also an associate professor at the Maurer School of Law. That's the name, right? In Indiana University, right? He'll be moderating the panel. Gabriela Horno, who is the data processing manager at the International Criminal Court in The Hague. Lindsay Freeman, who's the director of technology, law, and policy at the Human Rights Center of Berkeley School of Law, and Enrique Piraces, I hope I pronounced that correctly, Enrique, who is a human rights technology program manager at the Center for Human Rights Science at Carnegie Mellon University. So without further ado, I really want to give you the floor, or the Zoom, as you will, Asaf, and take the discussion from here. Thank you.
Thank you so much, Ayelet. And I'm really honored and delighted to be here. I think this is such a timely and relevant conversation, and we couldn't have a better panel to conduct this discussion. To kind of set the scene, let me give you an example of one organization not represented on the members of the panel, and that's the Icrc. In contemporary day, the Icrc, in running its mandate and executing its mandate, needs to engage in a lot of data-intensive practices. For example, the Icrc will need to rely on data analytics and artificial intelligence to predict emergencies and allocate resources for disaster relief, or it will need to use cash transfer programs and biometric collection in the management of facilities for refugees and asylum seekers. Or you might rely on the use of drones and social media applications in the collection of evidence of abuses of rules of international humanitarian law. And that is just one organization. There are many others, and all of them have turned to big data as a mean of engaging in their practices. And so the question then becomes, to what extent does regulation of that data is governed by any standards of international law or best practices, and to what extent these organizations should and how they do adopt these principles into their day-to-day operations. In that regard, in the last decade, we've seen the mushrooming of a number of frameworks and arrangements. I'll just name it a couple that to kind of whet the appetite and engage some of our audience. The UN International Organization of Migration introduced a data protection framework. The UN Office of the High Commissioner for Refugees and introduced a data protection framework. The UN World Food Program, the United Nations Office for the Coordination of Humanitarian Affairs, OCHA, as well as various international organizations like Oxfam and Medicine Sans Frontiers, as well as the Icrc, all introduce various data protection policies and frameworks, which they have now internalized to set some of the standards internally for their operations. And yet there's a lot of legal uncertainty around these frameworks and the extent to which they are binding legal rules that could constrain the operations of these agencies and can be used as a tool to hold them to account whenever data breaches or data intrusions occur in the process of their activities. And so what we're hoping to achieve in the course of our discussion today is a preliminary mapping of the kind of challenges that international courts and international organizations are faced with in dealing in these intensive data practices, to learn more about what makes the application of these rules challenging and to identify success stories or suggested frameworks for more organizations to follow. And this is really a preliminary conversations that many of these organizations are having, especially in the wake of more and more domestic national frameworks for data protections, which have ballooned over the last few years around the world. I just want to mention one book that had just come out. This is, I'll admit, I'm self-promoting a little bit, but this book just came out with NATO CCDCOE 2 weeks ago. It's titled The Right to Privacy and Data Protection in Times of Armed Conflict. And it really is an attempt to map out the role that data protection and privacy play in the operation of humanitarian organizations, militaries, governments, and other non-state actors. And it devotes a significant portion to looking at the role that it plays in the work of international courts and organizations. And so I put in the chat a link to that book. It's available open access. I'll mention another book that is forthcoming. That one is titled Big Data and Armed Conflict: Legal Issues Above and Below the Armed Conflict Threshold by Laura Dickinson and Edward Berg. It's coming out later this year with Oxford University Press. That book too attempts to ask difficult questions about the application of big data in humanitarian activities. Okay, that was all that I wanted to say at the outset. I hope that I've whetted the appetite enough. And what we will do in terms of the structure moving forward is that we've asked each of our panelists to take about 10 minutes to provide us with some opening remarks from their experiences and their background. We'll go in order: Gabriela, Lindsay, and then Enrique. We will then engage in some questions and answers between the five of us before opening it up for questions from the audience. So I do invite the audience, as you're hearing our panelists speak, to put questions in the Q&A function, and we'll be sure to take those on throughout the panel later today. All right, so with that, no further ado, please take it away, Gabriela.
Thank you, Asaf, and thank you for inviting me to the ASIL panel. It's it's a great opportunity. I want to test this principle of the more you share, the more you learn. So I want to learn a lot, and I'll try to be as candid as possible within the constraints of my organization. So it's just to note. I want to just briefly discuss the role of electronic data in the work of the ICC and present introduce some of the challenges that we encounter in our environment. I can compare it a little bit with other organizations. I've been, I'm member of a peer group here in The Hague. And what I would like to list is the measures that we are taking, or that we've already taken to palliate the challenges or to deal with the challenges. So just to start, the court uses electronic data in three areas. One is administration, like everybody else, just to manage resources. So I'm going to leave that apart. And I think that what is more interesting in this forum is the use of data for managing operational risks, we gather a lot of information in order to protect our operations and also to fulfill our mandate to protect those that come in contact with the court. So it can be witnesses, victims, but also staff, contractors, interns. We want to keep, well, we are mandated to keep everybody safe, and we really want to keep everybody safe. And then it's also the super important part of the data that, so the mass of data is gathered for the real core business, that is investigate crimes in the areas of interest and to prosecute and to have the legal proceedings where it's necessary. There are some factors that make well, I will explain the challenge later, but I wanted to express 3 factors that really increase them in our environment. The first is that we investigate situations in many areas, and some of them are mild, but some of them really gain us powerful enemies. So that's a challenge for that actually just reinforces our challenges. Then the areas where we operate, so not only our situation countries, those are also risky in some senses. So that's also a challenge. And then the diversity of our staff, that we are all from different cultural backgrounds and very different professional backgrounds, and we are all mixed together here. So we have different interpretations, we all want to operate in a comfortable way. So that's affecting the different challenges and how we all see them and how we approach them. So that's it. First, the data that we need to protect. We have private and personal information that we need to protect. We have operational and core business data that can be sensitive, and information that we receive from other sources and that may be under conditions of confidentiality. So we are very well, not flexible, but we are very stringent on and adaptable to the type of information that we are protecting. Sometimes we are expected from outside, from third parties, to be more stringent. So back to the challenges, there are 2 specific contexts of the challenges. One is the ones that we face at the point of collection of the data, and then the other one that is more related to the storage, processing, and review of the data. So at the time of collection, the 3 main challenges are the large number of online data sources and data formats that we encounter when we are doing online research. There are often multiple versions of the same content because it's created by different sources, and then we cannot efficiently identify duplicates at the point of collection. So we may collect the same content in multiple manners. An example can be that we may obtain a database with some data, but then we also receive the report in PDF from somebody else and a Word document that contains the same data. So yeah, when you're collecting it, there's no easy way of distinguishing that. So we may have an over collection there, and we need to apply different processes later on that are not always efficient. Then we are facing social media and large volumes of user-generated content that makes it difficult to validate the sources and to authenticate the data that we received. So there is the risk of not being able to identify in a timely manner any deep fakes or any forged evidence that we receive. And yeah, that can become a problem later on in the proceedings. And then there is also the issues of privacy and, of course, proportionality of the making sure that we don't over collect, and we can always maintain the privacy. The third challenge at the stage of collection is that the areas where we investigate, they may be using different platforms, different social platforms, and they use the internet in different ways because yeah, we are focusing very distinct parts of the world. And that means that we need to operate in very distinct very different landscapes. So we need to adapt our methods of investigation and collection to wherever we are, to the behaviors of the places that where we are operating. And it's also the matter of the language. So different world areas, they have not always very simple languages. And as an example, if you look at Google Translate, some of the languages that we have to deal with, they don't appear at all there. It's a big challenge. So the first two challenges that I mentioned, they are faced by other international organizations that I've been in contact with, but the third one is really exacerbated by our own context. So others may feel it in a more limited way, but yeah, for us, it's very important. The measures that we are developing or that we've implemented, we're focusing on increasing the number of processes based on artificial intelligence for collection and for processing. So we're now having data scientists with us, and also we created a manual on online investigations that was created with the help of Lindsay. Thank you. And we try to keep it current. So every time we find something new, we try to make sure that it's incorporated in the manual, and that the manual is embraced by everybody here, that we really implement it, because it establishes some principles that are essential for us, like objectivity, proportionality, security, adaptability. And then the third measure the third and last measure that we have in this regard is the preparation and update of assessments of the areas where we are doing online investigations. So before we launch on using the same techniques, we try to see that we're not making a mistake, and that we're really finding what we're looking for. Well, we're taking the most appropriate approach. So now, passing to the next challenges, to the storage, processing, and review of the data that we collect. So we have the new challenge of using cloud-based tools, because then we don't have the full control over the security that the companies embed in the tools. There are 4 challenges in total, just so that you know. So the second one is we still use outdated on-premise systems. That's a common challenge for other international organizations as well. We don't have big budgets usually, so it takes a while to update our systems, which means that we are keeping our information in different systems that have different data models, and they don't communicate with each other. We cannot integrate. So then we're duplicating where we store the information for different purposes. And this causes inefficiencies. And that means that some of our more entrepreneurial users may try to find creative workarounds, which are not always safe. So yeah, that's a challenge. And then the third one is that the information governance framework is not optimized. Usually, yeah, it's a common problem in different international organizations, that the emphasis is not put on information governance. It's put on the main business, as seem more relevant, of course. So that means that our policies are not always overarching, so they are more fragmented, and also that the practice, the implementation of those policies can be inconsistent. This is exacerbated in our case because first, because of our structure. So for instance, it's natural, it's in a way that our security classification is very different between the legal security classification for the purpose of trials from the rest of the information that we manage. And then, yeah, inconsistent practices. I said earlier that we are a very diverse group. So of course, we all interpret policies in different ways, or we want to address them with our own ways that we bring from our cultures and so. And the last challenge here is the risk of cyber attacks. So because of the large number of cases and the diverse geographical distribution, as I said, we have we may have powerful enemies in some places. It means that the actors may be more sophisticated, the threat actors, and the attacks can be taken in more complex forms. And we are not attacked for financial benefits, but to really influence our investigations or our trials. So yeah, so far we haven't suffered any big attacks. We need to be prepared just in case. The measures that we've been taking in this regard is we have very stringent procurement practices that include a careful assessment of the tools that we want to consider, but also of the vendors. And then we also establish very strict legal contracts with them so that we can manage the risk that we identify. Then we continuously assess the environment for new threats. And we regularly have awareness trainings for staff just to make sure that first they don't fail on doing what they already know, but also that they know how to react to new approaches from attackers. Then, of course, we're trying to replace outdated systems. It comes slowly, but it comes. And then, but we have also started developing applications using low code, and that allows us to create applications that have more interoperability, and that really helps. And we're also increasing the use of artificial intelligence for these purposes as well. And finally, we are trying to strengthen the information governance by establishing clear roles across the whole organization, and also by making more transparent decision-making processes also across the organization. So yeah, that's as much as I wanted to say.
That was perfect, and a great way to set up the kind of challenges and solutions that international courts and organizations have taken. I'll say that many of the things you highlighted, including the procurement issues, including the cyber attack issues, are the kinds that international courts and organizations across the board have all been facing in similar and varied ways. When we get to the Q&A, I have some I would love to hear more about some of these solutions, because every solution kind of introduce new kind of challenges to implement. So, but we'll move right along. So our next speaker is Lindsay. Take it away.
Thank you so much. And thank you for having me. It's great to be here and great to be with this panel. I'm so glad this conversation is happening now, because it is so timely and so important. I really think information and evidence management might be to some a boring issue, but right now is the most essential in war crimes investigations, and particularly in the context of what's going on in Ukraine. So I'm going to talk about two kind of projects and areas that we've been working on at the Berkeley Human Rights Center. The first is the Berkeley Protocol on Digital Open Source Investigations, which is the first set of international standards for doing digital investigations using publicly available information. And this was a 3-year project that we worked on actually in parallel to the manual that Gabby mentioned. So the processes informed each other, and while they are different, and the OTP obviously has very specific considerations, the two documents are consistent. So what the publicly available document is, provides guidance to investigators that might be from other international organizations, national law enforcement, NGOs, but can have a process and kind of meet the minimum standards of how they do their work in a way to maximize the chances that what they're doing will be useful to prosecutors in a court of law as evidence. So that's one thing. And then I also will talk a little bit about some ongoing conversations with social media companies. So, you know, some of the open source information comes from social media, and that's sort of one set of issues is the people collecting it and downloading it just directly from the internet. But the social media, the media companies themselves have sort of different data sets on top of what you see publicly, like the metadata and user data that come with it that can be really important for authenticating that information. And often judges still sort of have a preference for getting the information directly from the tech companies. At the same time, there's also an issue of the tech companies remove a fair amount of content that violates their terms of service. And often this is some of the content with the most evidentiary value, because it might be showing a violent attack that is a crime in and of itself, or have, you know, useful lead information, and it can be removed before investigators have a chance to preserve it. So I'll tell you a little bit about where those conversations stand, and some have been sped up because these issues and challenges really need to be addressed in the context of Ukraine, because it's happening right now. So there's no time to wait. But just to give a little information on the Berkeley protocol and the background to that project, it started maybe years earlier, but really launched officially with a conference in 2017, where experts from international tribunals, academia, NGOs, investigators, law enforcement, journalists came together to talk about sort of issues around digital open source investigations. It came sort of right after the Alwer Folly arrest warrant was issued by the International Criminal Court, which was the first arrest warrant to rely primarily on 7 videos that were found on Facebook and other social media, and showing that this kind of content could be evidence in and of itself and not just lead information, which is how it was primarily being used up until that point. It was also prompted by what was going on in Syria, where there wasn't a clear accountability mechanism for that. So a lot of NGOs jumped in to try and preserve the thousands, hundreds of thousands, probably millions of videos on YouTube showing the Syrian conflict in the mass volume, and having different groups collecting it in different ways without any sort of guidance out there makes things really, really complicated. So that's when we really recognize the need for some standardization. So over the course of 3 years, we did over 150 consultations with digital investigators, technologists, lawyers, judges, analysts, across disciplines. So law enforcement, military intelligence, and other civilian intelligence, human rights activists, human rights advocates, investigative journalists, to kind of identify what common practices had already emerged, and to identify sort of pain points or points of tension. We had 4 workshops that dealt with different issues where there were those points of tension, and in particular around ethical issues was something that was discussed a lot. And yeah, and we had a pretty, a lot of people weighed in on the process, and a lot of people were involved in this through the workshops, but the advisory committee and editorial committee as well. And one of the things we really focused on was principles, lasting principles that you could apply as the technology changes. Because when we first did a sort of literature review of what was already out there, we quickly realized that there was a huge problem in things were being published and becoming obsolete very, very quickly because they were all technology or tool specific. So the Berkeley protocol is tool agnostic for that reason. We wanted to future-proof it to the best degree possible. And we categorize the principles as professional principles, methodological principles, and ethical principles. I'm just going to focus on two, which are the principle of data minimization and the principle of preservation, which themselves are at tension in many ways. So the principle of data minimization came a bit from the European General Data Protection Regulation, or at least that sort of language and idea was drawn from that. And this is the principle that you should only be collecting and preserving information that is necessary for a specific purpose that is justified by that purpose and proportional to how you need to use it. And that then came from, I think, a change in thinking. Sort of a decade ago, if you go back, the approach for law enforcement, intelligence agencies was really, let's run a dragnet across the whole internet. We want everything. We don't want to lose anything at all. And that has changed for two reasons. One, it's incredibly inefficient because you don't have the human capacity to actually make sense of it. As AI improves, that might change a bit, but I don't think the technology is really truly there yet. But also because of the Edward Snowden disclosures and the cases at the European Court of Human Rights that came out of that, and you have this sort of growing and evolving jurisprudence on the right to privacy, that's really, really important. So those were two of the things that have sort of changed what the approach should be. And you know, in preventing overcollection is also particularly important in the context of prosecutors' offices that have disclosure obligations, where they need to review everything they have. They need to know what's in, you know, their possession and custody. And if you're scraping a huge amount of data, much of which might be irrelevant, and you're catching everything in your net, it's going to be impossible to comply with your disclosure obligations. So that was another reasoning for taking this sort of data minimization approach. And you can already see it now in the context of Ukraine. There are a lot of people who are trying to collect everything, just mass amounts of data. And I'm quite skeptical on whether any of this will be relevant in actual cases. Yeah, we're trying to encourage people really to kind of come up with a strategic approach to how they might do this work and how they might collect, and being able to articulate their reason for, you know, collecting content from social media. At the same time, though, data minimization has to be balanced with the issue of preservation. And as I mentioned, there's a lot of these takedowns from social media companies. It's also one of the most useful categories of evidence is like perpetrator content, as we call it, or perpetrator videos where they post it themselves, or it might be a potential perpetrator just stating their aims or, you know, inciting violence or different types of crimes online, where then they realize that that might be problematic for them down the road and take it down themselves. So because of this, there is a need to be very proactive in the preservation process. And this has become an issue with the sort of fire hose of information coming out on Ukraine. You know, do you preserve it all? How do you set parameters up for what's going to need to be preserved? Because you might not be able to do that really itemized review in time, just because of the speed and volume at which information is coming out. So yeah, that's a sort of balance there. With the Berkeley protocol, sort of since it's been out, it came out in December 2020. We've done lots of trainings with lots of different groups, international organizations, as well as civil society groups from many different contexts, and training them on this work. But really, it wasn't until Ukraine that I saw it just sort of adopted on its own without us being there. The Office of the Prosecutor General in Ukraine took the initiative to translate it into Ukrainian, which is great. We found out about that afterwards. And a lot of the Ukrainian groups have really early on just started doing this, which is really important in documenting their work and being more intentional about the data they collect. And thank you for putting in the link there. So that's one area. Of course, because that deals with publicly available information only, it can be sort of less concerning to privacy advocates or just people in general, because there is at least some consent in people putting the information out there publicly and sort of knowing, you know, once you post something on the internet, you do sort of lose control over it, and that's just the nature of the internet. But a lot of information, digital information, is closed source, and a sort of increasingly important area of digital evidence is information from service providers. So that might be telecommunications service providers. And you saw in the case at the Special Tribunal of Lebanon, where cell phone data, call data records, was one of the most important types of evidence introduced. And in order to do that case, they collected very broadly. They took like the entire country's cell phone records for several months leading up to the attack, which is a net too broad that would never sort of comply with laws, at least in the US, that are there to protect privacy and have sort of the requirement for specificity in Fourth Amendment rules. And there's very similar comparable rules in Europe as well. So this is something where social media companies as well, you know, they have a lot of this content, are wanting to be really helpful, but they have a huge challenge. And I don't want to underplay, this is a really, really hard challenge to figure out, because there are so many laws that conflict with each other that they don't even know like how to comply, because if they comply with one, they might be breaching the other. So this has been an issue on what they can collect and what they have to collect, and then what they can collect, what they have to share, what they can share, sort of a way of breaking it up and thinking about it. And we've really broken down the issue to preservation as one thing, and then access is another, with access being something where there's even a heightened, more heightened privacy implications to that. So with the goal of being as privacy conscious, security conscious as possible, and complying with data minimization or data protection laws, trying to figure out ways we can sort of balance that with this need to preserve, where these tech companies might be in the best place to do it, certainly have the best infrastructure and financial resources to do it, but how to set those parameters. So those are ongoing discussions, and ones that I think will become more public very, very soon, as there is sort of urgent need for problem solving. At the same time, it is hard to come up with a solution, because there's a huge pipeline of a bunch of new content moderation regulations coming down, and that's going to dictate a lot of the rules around retention policies that they'll have to comply with. So it is a bit of an issue to sort of come up with a plan that might be derailed very soon by new regulations coming in. But how we've been thinking about it and how we've broken it down, and I'll just say this and then turn it over, and happy to answer any questions on it. But we really look at the issue as from the technical point of view, the operational point of view, legal point of view, and policy point of view. And so really breaking down those issues and challenges. The IT infrastructure is one. None of these international organizations have the technical infrastructure they need to be doing the job they need to keep the information secure, to manage it at the volume. And that's really going to be important for states to understand the need to invest significantly in technical infrastructure. We've also been doing a lot of research on sort of tech forecasting for the purpose of international justice. which is something that kind of came from the issues of procurement Gabby mentioned at the ICC and in other UN bodies, where there are very strict procurement procedures that can take a really, really long time. And sometimes by the time you actually purchase the technology, it's become obsolete and there's something new there. So we've been doing a lot of trying to predict or see what's coming down, in the 3 to 5 year range, and try and anticipate what's going to be needed, so that maybe we can get some of those processes started, or at least all the international tribunals and organizations doing this work will be better prepared for what's to come. Thank you.
Thank you so much, Lindsay. This was terrific. I want to highlight one observation I think came across from your presentation. So much of the principles that the protocol relied on were built by analogy on existing frameworks. You had mentioned the GDPR, you had mentioned the European Court of Human Rights case law post-Snowden. And I think that there's a lot of, to the lawyers in the audience, there's a lot of interesting questions about the extent to which obviously these rules do not apply to these international courts and organizations as a matter of existing law, partially because these organizations are subject to certain privileges and immunities, partially because some of these frameworks were never meant to cover international courts and organizations. You might think about human rights law as one example of that. I'll mention, you had mentioned the El Ayash decision from the Special Tribunal for Lebanon. There, the court explicitly says, I'm a Chapter 7 court, I'm above human rights frameworks. And so there's interesting questions about the extent to which everything we're talking about goes beyond the voluntary things that these entities take upon themselves out of their desire to do so for their own efficiency versus a legal obligation to do so as a matter of international law, which maybe we'll get back to in the Q&A. But with that, I'm moving it on to Enrique. I'm looking forward to your observations.
Hello, everyone. Thank you for the opportunity to kind of like listen to what has been shared, and the future opportunity to listen to what people may want to ask or the reflections that they may have. I'll try to, well, my name is Enrique Piraces. I work for the Center for Human Rights Science. And one of the things that perhaps you need to know is that I'm not a lawyer, I'm not an engineer, I'm not an academic. And I'm saying that because I think that for this conversation, I am a human rights practitioner. And most of my practice has come from the intersection of human rights and technology, with a dash of creativity or innovation here and then. And that experience has been, even if from my perspective has been extensive, is only a small reflection of the things that are possible or the possible things that can be seen. So there's a little bit of probably quite obvious bias in what I'm sharing with you, but all of that I'll try to do not only in a candid manner, but also with the idea of highlighting some things that I think could be that have been interesting discoveries or lessons learned, and that I think may be at least interesting data points for future conversations that some of you may have. So when I was invited to this panel, one of the reasons I was invited, I assume, besides being college of some of you, is that I wrote this little piece on an academic journal. It was a book, actually, it's an edit volume, around the future of human rights practice. And there I share some reflections around, what kind of things may lay ahead, how they may impact human rights practice, and a few other considerations. And I think that some of those may be relevant for the conversation that we are having in terms of data and the responsibility of some international organizations and tribunals. And some of the reflections that I shared there are perhaps about the way technology moves, considering that technology is it's something that it's fluid and it's very hard to kind of define, and that it's a pretty lively subject if there's such a thing. It's a thing that it's big and ever changing at a really fast pace, and these are all cliches that we have heard, in different ways. International organizations and tribunals may share the size here and then, but definitely don't move at a fast pace, right? So there is a kind of like an ethos level, like some, this may be even unnecessary to really like dive into, but there's like a big challenge in terms of like, there's these two things that intersect that just move at almost conflicting speeds in a high level. So one of the things that we have been kind of like realizing is that this has like different forms of impact. For example, one of the things that we have realized is that many of the things that we do are actually quite uneducated in terms of technology. Like most of us, right, don't really have a good understanding of technology. And that means also we don't have a good understanding of the kind of data that is produced, right? Like, or the kind of data that could be produced. Most of us tend to think of technology as the internet, social media, mobile phones, perhaps browser. And most of us will pretty much work at that level. And that means that the type of data that we can assume is created, moved, or is possible to be available for analysis, or that perhaps needs to be protected is that kind of data. But the reality is that technology is much more complex. It's much more complex. It's much more than that. And some of the things start to become relevant, especially for some of you that are interested in, how is that certain jurisdictions may have an impact on the type of data. And it's because a lot of these things actually do not exist in the wild, right? Like with the exception of those things that we transmit over the air, like the vast majority of these things in nature don't exist in a place that is just in the world. Most of our interactions with technology happen in private property. Most of our, and if it's not only private, it's often, and it's quite likely to be the majority of the cases, commercial private property, right? Like the things that we are saying don't exist in the same place that you and I exist. Well, this is cool, it's a good example. But if we were in the same room, like, in a pre-pandemic environment, those interactions are interactions that we own, that happen in a space that we share, and that they move through the air that we have already assumed in different ways that we share. These other spaces are not that, right? Like the cables, the servers, like the software is owned by someone else. And I think that that is perhaps one of the first places where the potential case that we do have a tremendous need for a much more sophisticated digital literacy than the one we have, right? And as a first kind of like rapid reflection, I would share that in terms of those things that may create some value in a conversation around responsibilities, possibilities of the future, it is definitely clear from my perspective, from my experience, that we need both digital literacy in terms of like a sufficient technological literacy to understand how things work, to understand, how some of these data are produced. And at the same time, and again, it may be secondary to the way I'm establishing the point, we also need, attached to this, a good understanding of data literacy in terms of pretty much as close as statistics as it may sound, right? There's some form of literacy that we are missing. And I think that this has a few interesting applications. Like when one think about the type of data that we are produced, when we think about privacy, most of the time we're thinking about something that for most of us is the reflection of some activity that we have online, like a log, right? A pen register of the 70s, or, or like your social media activity. Perhaps for some of us, if we feel a bit more sophisticated, we may think about cell tower records, but there's a number of things that are very kind of finite. All of them, for most of us, may be able to look almost like as if they will be to be printed, right? And there will be a significant collection of packages. But the type of things that we're seeing ahead are things that are going to become increasingly more sophisticated. And one thing that I would argue is that we are going to get to a point sooner rather than later where what is being recorded is pretty much everybody's complete human experience, right? What we're going to be doing is something that is going to be just much more than, the log activity on a thing. There's going to be data created about pretty much everything that you are doing. And again, it's a bit of an exaggeration on purpose, but it's quite likely going to be of that scale. We're going to have data that is going to require much more of an immersive kind of type of interface. We're going to be able then to replicate, to repeat, to replay someone's life. And you can insert here the link to some of those movies that were created before the internet. But I think that in that sense, I think that one of the literacies that we're missing is a literacy about the future, about the things that are possible. Most of the conversation about protection, especially the one in the legal space, is reactive, right? It's trying to solve a huge problem that we have created that is creating significant damage at different levels, but is by nature reactive. It's not really thinking about preparing for a future that is different. It's trying to protect us from things that are happening today for them to perpetuate. But there's things ahead that are much more different. So to give you an example, and some of you may have seen what Elon Musk has been talking in terms of like interacting with one's brain, right? Like the possibility of us to do something with information that we create in our brains. And to bring that rapidly into some form of sci-fi scenario, this could mean that in a future where material sciences and software development and bioengineering get us not so far from today, where we're able to download someone's memories, the experience of your life. You can think of this as, how convenient it could be for an interrogator to say, hey, were you there? Yeah, well, we may be getting to a place like that. But it also may mean that we can probably insert data back. But at some point, we're going to be able to, if that's true, in this sci-fi scenario, we're going to be able to download the experience of your life. And one of the things that could be interesting is that not only the technology is going to be different in that case, there's going to be other forms of data, other forms of collection that are going to be way different than this, but also probably there's going to be different understanding of, what are these data and where does this data starts to become kind of like part even of our own conscious. Like there's going to be things that I think we're going to see in the future where those data that we are collecting may be treated not with personhood in the way we treat companies with limited liability, not that type of personhood, but we can attach them almost as part of our organism, right? Like in the same way that, my heart is not something that could be treated differently because it's a part of me. So I think that's, there's some things ahead that may change our perspective on how things are going to be going. And I think that this is also becoming important for much more practical reasons. For example, when Gabriela kindly shared with us some of the challenges that organizations like the ICC have, we see things related to volume, related to storage, and often related to the privacy of the data that is often sensitive, right? We are making a lot of those assumptions based on the technology that we have today, right? That today we store some of that data in a hard drive, right? That often it could be accessible over certain networks, and that is at risk given the type of protocols that we use. But the reality is that the future may have something different from us. I have shared this in different panels where I believe I have been with Lindsay, where I have shared, for example, there is advancements in cryptography or computer science related to encryption, like secure multi-party computation, homomorphic encryption, and other fantastically sounding work that may alter the way we treat data. That may mean, for example, that data doesn't need to be protected in the ways that we do, that maybe the challenges around data protection are different. And if that is the case, perhaps some of our concerns about privacy will be different. And this is a bit of optimism mixing that. But the point is that they may be significantly different than today. And the laws that we have today, the practices, the principles that we have today are most likely not going to be as valuable then, and we're going to be missing a few others. In thinking of that, there's a few other things that I think are going to become kind of like relevant to the type of uses that we have of data. Right now, we think a lot of data and privacy in terms of like the responsibility that we have, or that we should have around third parties. And it's often something that we consider necessary for certain practices around, let's say, evidence gathering, or perhaps accountability, or perhaps bringing things into a court. But there's going to be some other things that are going to perhaps change our possibilities. One of them is, as I was mentioning before, we're going to have the opportunity to replay. There's going to be enough data for us to replay. And that's stuff that is possible today. If you think that we can collect information about our behavior beyond what we write or what we see. But there's going to be some aspects of human rights practice in particular, of what I think also like evidence analysis, that are going to require different amounts of data. If you think about event reconstruction, the possibility that we have to kind of like replay today events like what C2 Studio, an organization based in Brooklyn, New York, did in the context of the Euromaidan protest in the Ukraine several years ago, when in the aftermath of that, they were able to provide the Ukrainian courts with material that collected composite information from cell towers, from LIDAR imagery and others into a court of law. I think that much of this information is not seen as super sensitive on its own, but when it's a composite, it's starting to change some of the ways we think about the value of some of this data. And I have a few other things that perhaps belong more to a conversation after questions. But for now, I think that many of the things that I could have shared were already expressed. And my point was to try to share a few things that could be a little bit different than from what we are used to discuss in the context of data privacy and the like.
That was terrific. Let me first note again to our audience that you're invited to ask. I see that there's only one question in the Q&A. We're invited to ask some more. We have about 20 minutes left for our discussion, and I'll take a couple questions at the beginning, but I really want to encourage our audience to ask any question you might have. One thing that you all have touched upon has to do with the commercial and market-based environment in which these activities are taking shape. And I'd be curious to hear more about the capacity of international courts and organizations to maneuver in this ever-changing dynamic market reality. And I might want to pose my question. It's for all of you, but I really want to pose it to Gabriela, who had done a good job in highlighting some of the challenges and the solutions that the ICC at least has taken. I'll kind of try and break it into two categories of regulation. One set of regulations is by contract. So to the extent that you're procuring, you might be able to regulate certain rules around data collection practices, cybersecurity practices through the contract that you're negotiating. But that obviously is only true to the extent that you have negotiation power to negotiate. And I can think of various international organizations and courts who might not have, vis-a-vis certain kinds of vendors, might not have the power to negotiate or the sophistication to negotiate. So that is one set of unique challenges there. The other part that was alluded to across all of your presentations has to do with regulation that happens before you even contract. And that is the way the vendors themselves code their products, the way the infrastructure is laid out, and you're operating within that system, and you're constrained by that system that was created. So one great example of that is the Rohingya genocide, the action at the ICJ. Facebook is creating certain restrictions on where data goes, and so the ability to get evidence of the genocide, the statements around that genocide, are just restricted from the Gambia because it's unable to access that information because Facebook's internal policies have denied them access to it. And so in thinking through the maneuvering of both these types of regulations, I'd be curious to hear how you've found successes and whether or not you're also introduced to challenges. And again, I really pose it to all of you to share some more thoughts.
That's an excellent question, very complicated. So the first part was on the contractual obligations and how we, the ability to negotiate, to have the negotiation power to really impose our needs in those discussions, in establishing the contract with the companies. I think that in general, that's one of the problems that some of the international organizations that I know of have, and is that well, if they cannot achieve what they want with the conditions that they want and the cost that they can afford, they just turn around. So you're stuck with obsolete systems forever, and which is a problem on its own. Or is and other ways are reorganizing your thoughts and your strategies about what you need, what is the technology that you need, and how to acquire it. So there are other ways there is we had we've been having the help of the Technology Advisory Board at the ICC. That Lindsay is, she knows a lot about that, and it's it's a supportive mechanism that helps you in that in finding creative solutions and better ways of doing things that are not constraints, but by the negotiation power that you may have with those companies. And I think a lot of organizations are now taking advantage of that collaboration with this type of processes with NGOs that can be supportive for these mechanisms. Then the other part was the regulation that is already embedded in the systems you were mentioning. And yeah, again, it's all about finding the creative workarounds. One way can be finding strong partners that can help you with achieve your goals. I cannot think, well, yeah, I think, yeah, that's something possible. I think that at unit that they were establishing different collaborations that permit them to overcome difficulties, and I'm not completely on top of that. In our case, we are more of the look for ways around, and if this evidence is not available, then where can you find similar evidence? And we've set up different projects to encourage the collaboration with even the civil society, or to engage with different partners to just find that way of obtaining the information that is that you can authenticate, that you can use in court, and that it's can be obtained without breaching any type of law, data protection, well, privacy concerns, and just to try, whatever we do, we always try to be as ethical in all ways. Sometimes, I don't know, ethics are considered differently by different cultures, so you can never assume that you're being completely 100% ethical, because I'm sure that somebody will come up and say, well, point something out. But I think we have very high standards in trying to achieve our goals creatively and ethically. I don't know if that helps. I
don't know if Lindsay and Enrique have any follow-ups on that. I will pose one question for the both of you specifically, just because it dovetails from your presentations. Lindsay, you had described the Berkeley protocol as tool agnostic. And I think one of the things that Enrique's presentation beautifully demonstrated is how different tools, different evolution of data processes might generate new tailored problems. And I think that there is a clash or a challenge there between an attempt to set principles that are applicable across the board versus the need to be responsive to kind of future-proofing reality in the light of evolving technologies and evolving practices. And I'd be curious to hear about your thoughts on that specifically.
Yeah, I have so many thoughts on all of that, your question prior as well. So just addressing some of the issues with tools. I mean, one thing we did in the Berkeley protocol as well, and didn't go that deep, but we do give an overview of the different types of tools available. If it's a free tool, if it's open source code versus closed source code, if it's a commercial product, and what the pros and cons of each are, and custom building, which is one thing. And so, yeah, I mean, I think high level principles can kind of be applied, but things change and you have to be able to change your thinking, which is going to be particularly hard in the international justice context. And, you know, Enrique described very well this tension, but just in doing the manual, I remember of making the suggestion that every 6 months it needs to be reviewed and revised, and like the gasp of how impossible that would be at an international organization. You know, just that would be too fast a timeline for them. Yeah, so there needs to be, I think, a lot of changes in training and adoption of technology to make the people working in these organizations more agile at adopting new things. And there just has to be an acceptance that things are going to change. So one thing, we've been getting a lot of requests lately or asking for advice on sort of what tools to use for preserving information, for analyzing big volumes of information, sort of what's available on the market. And everyone gets very disappointed when we say there's no silver bullet. Like, it's not going to be one tool ever. And, you know, trying to have the one tool that, you know, solves all the issues in the entire workflow is not going to be a good tool, because it will be trying to do too many things. So I think one thing we've learned is, you know, there's no one stop shop and you have to look at different tools. So you're going to have a collection of tools in your toolkit that you're going to need to do this work, and they're going to change over the time. So one just really important thing, I think, is sort of constant training on technology. Like, we had some preliminary conversations about just doing something like brown bag lunches for lawyers to come in and hear like what's going on, what's new in technology on different issues, and keeping them informed and in the loop, because there's a lot of things happening that might not seem immediately relevant. And then suddenly a conflict happens and they see, you know, all this drone footage coming out, and then, you know, all these questions come about processing that material, authenticating that material. So yeah, I think there's a real need for a shift in thinking that happens, and just seeing the technology not as something separate that, you know, the IT person in the organization is going to solve, but something everyone is a part of, everyone's responsible for. And yeah, I mean, one issue you got at too is like, there aren't really any tools that are made for purpose for these international organizations, because there's not a financial market for it. You know, tools get built when there's financial incentives, and international justice is not, you know, there's not a huge amount of money in building it. So you do have some NGOs and smaller groups trying to build tools, but to match the scale and the security needs, particularly, as Gabby mentioned, increasing risk of cyber attacks, you know, a small NGO is just not going to be able to handle that. And there's commercial tools on the market, but they have to be tweaked because they're not made for purpose. So that's just a bit of an issue, is finding that balance, and, you know, where the investment is. Do you invest in a commercial tool and try and adjust it, or do you custom build your own? There's a lot of issues with that. Yeah, also just continuing over time, making sure you get tools that are going to have lasting customer support and not go bankrupt, as a lot of startups do. You know, so yeah, if you're going to invest in something long-term, they're really, like, if it's cloud computing, there's basically 3 options for that, right? Like, if you want a lasting cloud service provider that you know is going to be there 10 years from now, 20 years from now, and that can handle the volume, there's not a ton of options out there for that. So those are just a few of reflections on that. I'll turn it back to you, but I'm happy to sort of address the question on deep fakes there.
Yes, why don't, we'll leave time for Enrique to then respond too, because I'll be curious, but let me kind of pose that question from the audience. It's just for the recording. The question asks, in the wake of misinformation and disinformation on social media, and how sophisticated it's getting. To what extent does specifically the Berkeley protocol in addressing open source investigations addresses these types of new challenges?
Yes, that's a great question because it's such a big issue now, and especially around conflicts where information warfare is like very much an important domain of what's happening. So there's just so much misinformation and disinformation, and faked material, mischaracterized material, staged videos. You know, there's all different ways things can be fake or, you know, unreliable. So one thing we do in our trainings is really being able to categorize and look at the different types of things that, you know, distinguishing disinformation from misinformation. But really it's the verification process, which is a human process. Tools are being developed to sort of identify deep fakes, but they don't seem to be that good at it. And a lot of deep fakes are getting past the digital forensic tools. And they're sort of always going to be ahead on how you fake the material and the tools used to identify it. So I really think the verification process of having a human analyst go through is absolutely essential. And one thing that was very intentional in the Berkeley protocol is we made this a 3-step process of 3 things to look at that are equally important. One is the content analysis. So if it's a video, if it's a document, what's actually in it. Technical analysis, looking at the metadata or EXIF data, if it's a photograph, you know, things that might come with the file format or be different indicators, and then the source analysis. And I think this is the most overlooked and the most important, and where there's a big issue, just because, you know, online, the anonymous, pseudonymous nature of the internet, you know, some people aren't even like taking the time to look at like the history, the posting history of an account, which can be really, really telling in, you know, what the motivations are, what the influence might be. So, you know, I think one, you know, getting more people to adopt this very thorough verification process and including source analysis in it, but also making people a bit more skeptical without completely losing faith in that facts exist, because facts do exist and there is a way to get to them, but still making people skeptical and knowing that sometimes there will be situations where you can't verify it and you can't use it and you have to use something else, and you have to be able to just admit when you can't verify them and you can't rely on them.
Enrique, we're coming by that time, but I want to give you the final say. I'd be curious to hear your reaction specifically to that previous discussion we had with Lindsay with regard to those tools and the way we conceptualize them.
I'll be as brief as I can. So one of the things that I have been doing is talking about how technology should be applied. I believe it will always be much better designed or developed in a context of transnational solidarity rather than international cooperation, something that is horizontal, not vertical. So in that sense, any technology that will be developed for humanitarian or human rights practice should be developed from a perspective different than international cooperation or commercial. That's one thing. I have been doing that as one of the few people working to provide technology for tribunals and organizations around evidence collection since 2008. That's my experience. I think that's the case. In terms of like issues around the future, I think that this goes back to the point of literacy. I think that we need to switch this away from IT departments. Organizations like that are bureaucratic. We're asking them to be creative when they can. Individual champions will be, but organizations don't allow that. You know, you have tremendous separation. That's why colleagues will have to find the workarounds in an organization, which is asking people to work double to find efficiency in an inefficient system. So one thing to consider is that these organizations are not going to change, right? We're not going to have a Silicon Valley attitude in an international organization for a bunch of valid reasons. So we need to understand that that is the reality. And if we want to have some serious kind of like good understanding of data, good application of technology, we're going to have to create environments where creativity is welcome, where there's like good literacy. And in terms of the last point around like literacy, as cheesy as it sounds, like, you know, when we invented this pencil, this was the one I had around, there was a time where someone had the pencil because it was expensive, because it was the only one, because it was hard to use. And you had to go to that person to use the pencil. They used to have with typewriters in Latin America in the 60s, even to the 70s. You have to go to the person. We act like that. And what we need to do is just let go of the pencil and share this knowledge. So, analysts, attorneys, judges, everybody knows a little bit of this. So we stop creating these gateways institutionally. And that's it.
Thank you. That was perfectly timed. So we're coming right at a time. Unfortunately, this conversation could have been done for 3 more hours, but we need to wrap up. I saw that there was one more question in the Q&A. I'm actually going to use that question. It asked about different jurisdictions and exceptions. It actually is a nice dovetail to an event we're hosting in 2 weeks. The Interest Group on International Law and Technology is hosting another event on June 30th, titled Data, Human Groups, and Norms, an exchange on international law and the data sphere. And it's going to talk exactly about these questions of data governance and the international frameworks of governing data governance, relying on colleagues from the Data Sphere Initiatives and the Internet and Jurisdiction Research Network. I apologize we didn't get to address that question now, but I'm hopeful we'll be able to do so in the next session. And I just want to thank everyone for coming, and to thank our panelists for a great discussion, and hopefully one that will lead to future conversations within our interest groups in the years to come, as these topics continue to stay timely and relevant.